Hi folks, this is going to be lecture number 1. Before you do the reading, I want to do a quick overview of what the reading is so that you can focus on the parts that I think are important. They may or may not be covered on the quiz. When you look at the quiz, because you can take it as often as you want, you can go back and look at the readings if I've missed something. This is what's important in terms of what you need to know. This book I sometimes call Lineberg. And this is the National Underwriter book, Tools and Techniques of Estate Planning, published by National Underwriter. But you'll notice the first author here is a guy named Steve Lineberg, and a fairly famous lawyer in the estate planning world. He publishes Number Cruncher, he publishes his own newsletter and so forth. You'll hear that name from time to time. So I refer to this book as Lineberg. And I've assigned chapters 1 through 6. That's what I've assigned every year. In the American College book, I assigned chapter 1 and 2. You'll see Fontaine's book, which I didn't bring with me, is much more theoretical, and it just provides an overview of fundamentals of estate planning. It's an easier read than this. It has larger font and so forth, and it uses more conversational language. But typically, it doesn't have enough content in terms of detail to warrant you using it as a true study guide. So it's more of a supplement to this book than it is a standalone text itself. Chapters 1 through 6. Chapter 1 is very important. So take a look very carefully at pages 1 through 7 of chapter 1 and the details there, the common mistakes of estate planning and kind of the bottom line principles of estate planning. You'll see at the conclusion of chapter 1 is a sample series of checklists that are done for husbands and wives with some estate, professionals, business owners, and the different kinds of problems that they have. I think this is probably important and something you may want to come back and look at later on in the year as you go through the semester. So for example, as we cover generation skipping transfer tax in the second half of the class, you may want to come back at this part of chapter 1 and the checklist for various circumstances, because there are discussions here of dealing with grandparents and dealing with those sorts of issues when you're going to be doing generation skipping. Dealing with owners of private corporations. When we get into stock redemptions in section 303 in the second half of the class, come back to chapter 1. Take a look at this overview and the checklists that the author of chapter 1 put together here, because these can be very helpful. For now, I think if you just skim through the checklist, maybe take a look at some of the areas that might peculiarly interest you in your practice. If you have a lot of corporate executives in your financial planning practice, or your target market is downtown San Francisco executives, pay attention to that part of the checklist. How would you address estate planning problems or concerns that those kinds of clients would have? Chapter 2, data gathering and analysis. This is typically done with a form. What I want you to do on chapter 2 is take a look at the confidential file that's on page 44 through 47 of my book, or of the Lineberg book, because when you do your final exam hypothetical, so part of your final exam is going to be to create this hypothetical, ideally a hypothetical couple or family. You're going to team up with a partner. I'm going to team you up with a partner. And the two of you are going to come up with a client couple. It may be a typical client you run across, or you may want to get very exotic and make it the third marriage of both spouses with multiple children of prior marriages, and one with a very high net worth estate and the other with a very low estate. You can use your creativity there. I will reserve the right to modify whatever you and your partner come up with before it gets assigned to another team for planning, to make sure that it's not so beyond the pale that it's impossible to plan the estate, or that it doesn't exist in real life and therefore it's absurd. That won't do either you or your other team any good. I want something that'll be difficult for the other team to plan, but not absurd. So take a look at this data form and begin to think about what sort of family you'd like to structure for your hypothetical. How many children? Do you want your children to have spouses and grandchildren? Do you want to build generation skipping into the potential plan? Do you want to have parents? Are the parents aged? Are the parents in a nursing home? Do the parents have wealth of their own? Do you expect to receive a large inheritance from the senior generation? How do you want to plan for that? Or how do you want to set up that hypothetical? And then there's a family tree chart on page 47. Again, very helpful in estate planning to draft this up. But when you take a look at this, think about, okay, what is your hypothetical family tree going to look like? All right. There is a sample form for further data gathering and analysis beginning in the 50s page. Again, fairly vanilla type information. Let's skip to chapter 3. Death sensitization for the estate planner. This chapter just underscores the fact that even though we tend in an academic setting to treat this very lightly, and these hypotheticals are pretty interesting, silly maybe, that the reality is when you have a client in your office, you're talking about their demise. And this chapter emphasizes the fact that these are real people and that you can't be, you have to be a very good listener when it comes to the client's own experience of their own mortality, if they've had the experience of losing a loved one themselves, especially if the client is in your office or in my office as a result of a recent death, a potential incapacity, the Alzheimer's diagnosis, the spot on the x-ray, a terminal diagnosis of some sort, or a life-threatening diagnosis. This chapter emphasizes the fact that these are real people, and you need to understand that the emotional component is probably more important than any of the quantitative things that we discuss. Even for very business-like, robotic, cold clients, what you'll see is this area, when we talk about their family, their childhood experiences, their own potential demise, their own potential incapacity, that they sober up very quickly, and it's something where you need to be sensitized to the fact that these are really sensitive issues. One way of dealing with a sensitive issue, though, is to bring some levity in it, and there's really no substitute for experience when it comes to how to approach that and how to be just silly enough about it to where that client that may have some reticence about discussing their own demise or the potential that their spouse after their death, the widow, will remarry somebody else. These are really tricky issues, and you'll see in some of the lectures that I do later in the course some of the techniques that I use to lighten the conversation from time to time without making it silly. So take a look at that. There's a little bit of cite of Kubler-Ross and some of the other psychologists who have dealt with grief and dying and some of the issues surrounding that, the psychological issues that hit a client. Chapter 4, the unauthorized practice of law. This varies from state to state. California is very liberal in terms of allowing financial advisors, document draftspeople, all sorts of professionals have intruded on the practice of law, and there are very few things that are left from the California Supreme Court's perspective that really are the practice of law. The key thing to know, though, is if you or a non-licensed attorney who is not licensed in California engage in the unauthorized practice of law, you could be subject to prosecution. As a practical matter, it never occurs. The state bar does not run around prosecuting businesses or trying to put people out of business for the unauthorized practice of law. More importantly, though, you can be disgorged of your fee, whatever that fee is. So if you're collecting a registered investment advisory fee, a percentage of assets under management, a financial planning fee, and you are engaged in the unauthorized practice of law, you are not allowed to earn that fee. And so as a practical matter, you're working for free if you're engaging in the unauthorized practice of law. That's something key to remember there. And the reason that chapter is so short is it does vary from state to state, and as I've indicated, in California, the rules are very liberal. If you want to know the case on that, it's called Bierbrauer, Brower, and you could probably Google that and find out the main California Supreme Court case on what constitutes the practice of law in California. Chapter 5, Ethics. I'm going to have a brief summary in the lecture component of this introduction about what I think you need to know in terms of ethics, but I think in general it'll be important to know the distinction between who has the highest possible fiduciary duty and which professionals have lesser and less of a fiduciary duty as you go down the ladder. And then finally, Chapter 6 is malpractice in estate planning, ways to avoid malpractice, the common sense recommendations to put all your retention agreements in writing. If you're an RIA, of course, you'll have an ADV4 that will all be in writing. But in addition to that, have that individual client sign a written retention agreement with your firm to ensure that it's consistent with both your ADV4, but consistent with what you're actually doing with that client and how you're planning their property. So that does it with the introduction. Take a look at chapters 1 through 6, and we'll talk to you in a bit after you've done your reading.